Hello, good. We are going to be talking about immigration, the latest news about adjustment of status as far as TPS holders are concerned. We got a couple good news, at least for now. Let me just get right into it. So let me share my screen with you. Yes. First of all, we have DHS announces extension of temporary protected status for Venezuela. Okay, so people were wondering, is Venezuela out of TPS? No, Venezuela is into TPS. So basically, they have extended TPS as usual. It has to come from the Secretary of Homeland Security Department. So it came about yesterday that they have extended it for 18 months. Okay, so for 18 months extension, the 18 months extension of TPS for Venezuela will be effective from September 10, 2022 to March 10, 2024. Only beneficiary under Venezuela existing designation and who were all already residing in the United States as of March 8, 2021 are eligible to register, like registering again, right, under this extension. So Venezuelans who arrived in the United States after March 8, that's the cutoff date, right? If you come after March 8, 2021, you are not eligible for TPS. But the good news is approximately 343,000 individuals are estimated to be eligible for TPS under the existing designation of Venezuela. That is the great news. And of course, it comes with employment authorization and stuff like that. You have to apply with both forms, right? And then it says that they will provide instruction. When it comes to it, they will provide instruction prior to September 9, 2022. Okay? So basically, that's the good news for TPS for Venezuela. But again, talking about the same TPS, we are going to answer this question about adjustment of status. Okay? First of all, what is adjustment of status, right? It's when you file the Form I-485 after you get approval or with an approved petition together, or without an approved petition, but with the petition that's going to make you approve for it, right? So you have to have an underlining petition in order to file for a green card. You can't just file a green card like that. Underlining petition or a reason, basis for it. So we're going to go here. This is the application, adjustment of status, the process by which somebody can get a green card without leaving the United States, if they qualify, of course. But what is the basis, the underlying reason why people have to file for adjustment of status? First of all, we go here. If you go on this is page 3 of the green card application, okay? Under what category are you filing adjustment of status? If you are immediate relative of a U.S. citizen and you file the Form I-130, are you filing it concurrently or you already filed it or it was already approved, then you can adjust status. If you are either relative of U.S. citizen or relative of a lawful permanent resident under the family base, right, using the Form I-130, then you can file for adjustment of status. Person admitted to the United States as fiancé, yeah, they can file for adjustment of status. Okay. Widow or widow of a U.S. citizen using the Form I-360, if you get approved or together, they can file. VAWA petitioner, they can file for adjustment of status. Okay. Worker, that's employment based. I-140, once you get approved, you can file. I-526, get approved, you can file for adjustment of status. Religious worker, the special immigrant, for those one, you have to wait for the approval first before you file because the visa is not immediately available. Religious worker, Form I-360, you wait. Once the visa becomes available, basically, first of all, you wait, you apply I-360, get approved, you wait. Once the visa becomes available, you apply for adjustment of status because you have to wait online, right? Then we have certain Afghan or Iraqi national, certain international broadcasters, certain G4. When they say certain, not everybody qualifies under those categories, okay? Asylum status, once your asylum has been granted, that's when you file. Or if you're a beneficiary after I-730 get granted, that's when you file. But asylum, remember, you have to wait for a full year, right, before you apply. It has different rules. Human trafficking victim or crime victim. So basically, victim of a crime. Sorry. After the form I-914 get approved, visa becomes available, then you file for green card. U visa, the same thing. After I-918 get approved, visa becomes available, then you file. So then we have the Cuban Adjustment Act. Under the Cuban, those are special programs. Have to be really qualified under those. And the Cuban Adjustment Act for battered spouses and children. We have dependent status under Haitian Refugee Immigrant Fairness Act, dependent status under the Haitian Refugee Immigrant Fairness Act of battered spouses and children. We have the Luxembourg parolee, diplomat, those people, Indochinese parolee adjustment of Act of 2000. Then we have diversity visa program. For this one, I talked about it, diversity visa program. If you're in the United States unlawfully, so basically with a visa that has expired, then you win a lottery. Can you adjust status? To challenge. The visa must be available at the time you're adjusting and at the time of approval. But because this diversity lottery program ends at the end of the fiscal year, which is September 30, sometimes the visa, when they come to your case, the visa is no longer available at the time of approval, then you might not adjust status. Most people don't really adjust under this one when they're here unlawfully present, okay? That we talked about it too. You can refer back to my other case. Then we have adjustment by registry. Then we have adjustment individual born in the United States under diplomatic status, okay? Those are the basis. Why are you adjusting, okay? Under what category are you adjusting? If you can't figure out what under what category you're adjusting the status, then probably you're not qualified. Or you can contact me so we can figure out under what category you are trying to adjust status and whether you qualify or not. Okay, and then you go here, that's when they talk about inadmissibility issues, right? Inadmissibility ground. So those questions, when you answer no to those questions, you have to know whether in your case a waiver is applicable. If a waiver is applicable, then you apply with a waiver. If not, then probably you don't qualify, because there are some offenses, immigration offenses that will render you inadmissible, and there's no waiver available, then you really cannot adjust status. Okay, I'm gonna stop sharing here and come back. So in conclusion, if you are a TPS holder who came to the US first time without inspection, so pretty much illegally, then later on you acquire TPS status, which is currently valid, right? And then you file for advanced parole and you were able to travel outside of the United States, then you came back. Now USCIS is amending its policies and saying that while you can adjust status, provided that you have a basis for it. For example, you have a family petition, like wife filing for you, and previously you couldn't because of unlawful entry, but now you can if you had traveled with advanced parole and then came back. That's what's going on. That's it. And provided that you do not have any other grounds of inadmissibility. Pretty much that's what it is. And you need a consultation. You can always call 202-751-2180. If you're abroad, please email Bijoux.Ngwanda, ESQ, at gmail.com. Again, consultation fees apply as usual. Okay? Until next time, bye-bye.